How are you all? Are you all fine? Okay. So, so did you go through the textbook? Whatever has been already completed in the class? Are you done? Are you done reading from the textbooks and revising? I remember giving you an assignment yesterday. I asked you to find out what is Article 142. Correct? So did you go through your textbook and did you find out what is Article 142? Okay. Okay. So someone tell me what is the purpose of Article 142? Why was Article 142 kept in the Constitution? Okay, before even answering that question, let me ask you, tell me the current affairs that is associated with Article 142. Have you come across any news in the newspaper regarding the usage of Article 142? Right. It states Supreme Court can make any order as it deems necessary in order to establish complete justice. Right. Manipur cabinet. Okay. Manipur cabinet issue. Definitely that's one of the answer. What else? Any other prominent example? So what is this Manipur cabinet issue? What about others? Did you go through the recent current affairs or anything associated with use or misuse of Article 142? Any other examples of Article 142, its usage? I don't know whether you're typing or you're not going to answer this question. So I think I should just continue. Okay. Supreme Court may pass in order to do complete justice. That's enforceable throughout India. OBC quota maximum of 50%. Okay, I don't know. I don't understand what is the relationship with Article 142 and OBC quota. Speaker failed to give a verdict on defection after 1 month given by the court. So Supreme Court banned him from entering the legislature. Very correct. It's a correct understanding. So in Manipur, as I told you, I don't know which batch I had discussed. It was during the time of discussion on defections. I used to point this example that Speaker plays a partisan role. Because Speaker belongs to a political party, so at times he plays a very partisan role and he would not take action again under anti-defection law. So he just delays. He delays taking an action. Okay, and that delay already in various other previous cases where Supreme Court has already given opinion, the judgment that Speaker failing to act on anti-defection law within an adequate time is a violation of his constitutional duties. Okay, so Supreme Court has taken such a view with respect to delays on the part of Speaker in dealing with complaints on anti-defection, complaints on defection. So, but still that problem is just going on. Speakers usually don't take action if the opposition parties, some of the MLAs, they come and jump to the ruling party, then the speakers usually do not take decision. They just play a partisan role. So that is why the Supreme Court had to intervene and it passed an order. So what a wide power, don't you think so? We have this concept called as separation of powers. One organ should not interfere in other organs. So we have a constitutional provision called as Article 122. What is Article 122? If you see that, it says that no part of the proceedings of the House shall be inquired by any court. So 122 deals with the legislature, it deals with parliament. And our constitution clearly mentions no procedure inside the parliament shall be inquired by any court. So that is how you maintain a distance between the institutions. You prevent one institution from becoming too dominant, right? But in spite of that, Supreme Court is passing this order. It is deciding whether a person should attend the session or not. So it's such a great power. Don't you think so? Yes or no? Why? It's because it is because of this provision in the Constitution. Article 142, power of Supreme Court to do complete justice. What is this word? Complete justice. Do you understand the theme of this discussion? Where I am taking you towards? Yes? Do you understand what is being discussed? I am discussing about a constitutional provision. See, Supreme Court's work is to adjudicate disputes. It can have a federal jurisdiction to adjudicate federal dispute. It can have an appellate jurisdiction to sit as a court of appeal. It can have a review jurisdiction to review its own orders. All that is fine. But why this power? Why this power of Article 142 under the Constitution? Do you think our constitution makers would have kept this power like this? If they would have known that Supreme Court can do all these things, Supreme Court will interfere into the functioning of judiciary, executive, legislature. Okay, so this case of Manipur, cabinet ministers being banned, prevented from entering into the legislatures because they are defective. They are members who have defected, and anti-defection law processes is pending. Meanwhile, Supreme Court orders them not to enter into legislature. So, don't you think this concept violates the principle of separation of powers? Give me an answer for that, yes or no? Don't you think this kind of an act of the judiciary violates the principles of separation of powers or not? What would be your answer? Yes, no. Binary question. Because if it's only when you answer this, I can ask you the next question. That is why. Yes. So, do you think constitution makers would have then kept this provision for this purpose only? Do you think it's been kept in the Constitution for Supreme Court to interfere into all other organs? Because as I told you, Article 122 is the explicit provision of the Constitution which says that no other organ, judiciary should not enter into this domain of legislature. In spite of that, you have a provision like Article 142. So it means that constitution makers had a different idea when they kept this provision. But in reality, the Supreme Court has interpreted it for its own convenience, and it has started using it to enter into the domains of other organs. That is what, not even an extraordinary situation. Nowhere it's the extraordinary situation word used in the Constitution. Okay. So the extraordinary power of Supreme Court is Article, I think 136 or 137, which is special leave petition. This is the extraordinary power in the hands of Supreme Court, that any court's order can be quashed and Supreme Court can take up its own case. So this is the extraordinary power. Usually special leave petitions will never be accepted. It is only in the rarest of the rare cases Supreme Court will entertain the special leave petition. Otherwise, the trust on the lower courts, lower tribunals will all be affected. So that would be a violation of the trust that people will have on the lower courts, right? So usually special leave petition is not entertained, because that would result in the quashing of the orders of the lower court, which will make it a laughing stock, which will make the order of lower court as a dummy order, correct? So usually it doesn't happen. Only in the rarest of the rare cases, special leave petition is even accepted. Okay, so special leave petition is for dealing with extraordinary situation where there is a miscarriage of justice. Why Article 142 has been kept? So what would be the intention of the constitution makers to have an article like Article 142? What do you think so? See, they have kept it so that Supreme Court need not be bound by any procedural constraints. For example, you have Supreme Court, you have High Court, and you have lower courts. As I told you, rape cases, murder cases, the trial begins from the Sessions Court, right? I'll just tell you, give you an idea about what happens in this trial. During the process of hearing, Ram, this is state of Tamil Nadu, right? Did I discuss with you about I think when we discuss about mercy petition, I think I have given you an idea about what the Supreme Court actually does. Yes? Did I give you the example to tell you that Supreme Court is not actually giving the punishment? Supreme Court is actually, it is upholding the claim of the state to punish Ram. Did I mention that when I discussed about mercy petition issues? Otherwise, I'll have to explain it again. That's why. Yes, so I have explained it. So what happens is now state is angry against Ram, correct? So state will produce witnesses. Ram is the accused. State will produce witness. Witness 1, witness 2. 3 people, state will bring, the state will say, government will say, these 3 people were there on the day of the crime. They are my witness. Ram will bring his own witness. Witness 1, witness 2. His friends to support his claim that he was not present on the day of the crime. And there will be evidences. Some paper proof will be there, some photo clipping that Ram was participating in a birthday celebration. All that will be added as the evidence on the Ram's part. Evidence 1, exhibit 2. State will have its own evidences. Fingerprint of Ram, cell phone network footprint of Ram's mobile connection. Okay, this is how witness, evidence, they are all produced before the court. And the judge will, so what happens during hearing? During hearing, what happens is the witness will be asked to give the statement. This witness will be asked to give the statement. Ram's lawyer will cross-question this person. State's lawyer, public prosecutor will cross-question these witnesses. These evidences will be questioned, right? And after this, there will be a linkage which will be established between everything, and a story will be constructed, right? There will be a story that will be constructed by whatever witnesses say. With that, an image will be constructed, and based on that image, the judge will give his verdict, correct? This is what will happen. Understand, it's a normal judicial process that once the case goes on appeal to High Court, once the trial is over, the trial is already over in the Sessions Court. Now Ram goes on an appeal to High Court. At that point, the established judicial practices, no new witnesses will be added. No new evidences can be added. That is why in the first trial court, in the Sessions Court, before the trial even begins, the first thing the judge will ask is, have you added all your witnesses and evidences? Okay, that's the most important thing. Okay, because at a later point of time, he will not be allowed to add any witness, or none of the parties will be allowed to add more witnesses or evidences. Okay, so can you tell me why? Why no new witnesses or evidences will be allowed to be added at a later point of time? Can you think about why? Chances of manipulation is higher, okay. In fact, all the scenes that you see in the movie, witnesses being produced and cross-examination happening, all that is happening only at the district level. When you go to the high court levels, if since I've been to, I've gone and attended my own hearing in the high court, I know how high court looks like. You don't actually, it's not like the people will come, witnesses will be examined, nothing. There, lawyers will all be sitting, and people can sit, judges will be sitting, that's all. I don't even remember having seen that trial podium. Okay, I don't even remember seeing such a thing in that high court. So in high courts, no hearing, no witnesses, none of them will be heard, nothing. The judgment of the lower courts will be taken up. The judges will go through the case. Lawyers on both sides will put forward their arguments, and the case will be disposed. This is how it actually works in high court and the Supreme Court levels. The reason why no new witnesses will be added is, let's say at the high court level, if one more witness has to be added, okay, on the part of the state, what if he says something that can completely destroy the credibility of all these witnesses? This entire story that Ram has committed this murder was constructed by comparing and cross-referencing each witness's claims, right? Whatever they have said, you listen to everything, and finally a picture has been constructed. a new witness comes and he says that witness 1 was on a trip to Bombay that time. So if witness 3 says that, then the entire story of witness 1 will collapse. If it collapses, maybe witness 2 would have also said something in relation to witness 1. His version will also collapse. The cross-examination will collapse. Everything will collapse. So which means that then once again you'll have to ask him to come and he has to be questioned. See, witness 3 is saying that you were on Bombay on that day. Is it true? Then if witness 1 says that, then once again a cross-examination should start. Too much of delays will happen. Nobody can get justice if this is the case. Already in India, the pendency is so huge. Justice takes a lot of time in India. Once you start allowing new witnesses to be added at each stage, 30, 40 years before a trial will get over. Okay, that is why it is an established principle. It is an established principle that at the higher levels, no new witnesses or evidences will be adduced. Okay, though it is an established principle, if Supreme Court feels so that no, maybe a very crucial evidence could have actually come out. Some crucial evidence that Ram did not do the murder. Okay, so the lawyer appealing in Supreme Court, he produces this evidence. Please look at this photograph. Ram was in Maldives enjoying on the beach on that day. Okay, so okay, not this kind of an example, maybe something else, because if that was the case, then already you would have had your airport flight tickets and everything. Maybe Ram was sick and he was actually infected with corona. Okay, so even though he didn't go to the hospital, all his family members were also affected with corona, and all of them were they were confined to their homes. And this can be maybe a new evidence, something like that. I'm just giving you a imaginary example. Some new evidence comes which adds more credibility to the claim of Ram, which is an undisputable proof. Okay, Supreme Court has a look at that and it feels that, oh yes, maybe Ram has failed to add that earlier. Okay, but at least this is very convincing. I don't think Ram would have actually committed the murder, and an innocent person should not go and die. If the Supreme Court feels so, it can just discard with all these procedures. It can even, if it decides, it can even hear the case from the scratch. It is for this reason, this provision has been kept by the constitution makers. It can pass any orders, it can pass any judgments. Nothing can bind the Supreme Court. It is to allow Supreme Court the independence from any conventions or any kind of procedures regarding judicial practices. It is for that purpose Article 142 was in fact kept in the Constitution. Okay, where is it evident? You take the Constituent Assembly debates, the draft of the debates, you have the margins. Okay, in the margins, after people started observing what is actually the thought of constitution makers, then they found that this is the reason why Article 142 was kept in the Constitution. But Supreme Court has interpreted the vagueness associated with this article to its own advantage, and it has started using this power to just come up with any kind of orders. Okay, any kind of orders or judgments. But we are fortunate, Supreme Court has not unnecessarily transcended its boundaries. It is only when there was a real necessity. I would in fact say that even though the Supreme Court has interpreted this power to give any kind of judgment in any kind of matter, Indian Supreme Court's approach has been a very cautious approach. It has never tried to usurp the powers of other agencies. But there is a potential threat that such an interpretation to Article 142 at any point of time in the future can give excessive power in the hands of judiciary. But do you think judiciary will unnecessarily interfere into the functioning of executive and legislature? Even though it has been interpreted, Article 142 has been interpreted by Supreme Court to give itself such wide latitude. But do you think in the future, Supreme Court would actually go and interfere unnecessarily into the functioning of legislative and executive? Yes or no? Do you think? Tell me. No, yes. I would say no. Why? Because we have the concept of checks and balances. Supreme Court judges becoming crazy, automatically they will be removed from their post once they start doing this as a routine matter. So Supreme Court also realizes its limits. Okay, otherwise they will be removed. Legislature will unify, opposition, ruling party, everybody will come together and they will pass a removal process against the judges. So they know their fine limits. That is why our system is more focused on achieving this checks and balances. Okay, all right. So this is the reason why Article 142 has been kept. And Supreme Court, how has it used? as someone has discussed, it is about this Manipur issue, Manipur Legislative Assembly issue. Where excessive delay on the part of speaker to proceed under anti-defection law had compelled the court to make orders under Article 142, preventing the member from entering into legislature. Okay, this is one example. What other examples do we have in the recent past? We have the example of Ayodhya verdict. We have the example of this Bhopal gas tragedy. So very rarely Supreme Court uses this power, not as a routine. So can someone tell me how Article 142 was used in the case of Ayodhya verdict? What had happened? Any idea how Article 142 was used so as to give relief, to do complete justice? What was the complete justice in the minds of the judges? Any answers? Yes, to favor both Hindus and Muslims and to bring an end to this case, right? Non-conversion of any worship places in the future. No. Okay, non-conversion of any places of worship in the future. Okay. Right, okay. Religious place cannot be demolished for other religion. Okay. So anybody? Do you know who all were accused? Do you know how many people were convicted in this case? See, there were two cases. One was a civil dispute, the other one was a criminal dispute when it comes to Ayodhya Babri Masjid issue. Okay. So that civil dispute is with respect to who has control over the land where the mosque was standing earlier. Who had control over the land where Babri Masjid stood? That is a civil dispute. Criminal case was with respect to a conspiracy to demolish a place of worship, a conspiracy to incite religious violence. Okay. So, do you know what was the outcome of criminal case? How many people were given imprisonment? How many people are convicted in the criminal case? See, you know, a mosque was demolished. You know, people involved in religious rioting, right? So, in spite of that, what was the verdict of the court in the Babri Masjid criminal case? The verdict was, why are you not answering? 0, right? So there is no proof that anybody. There are hundreds of accused, but the main accused, all of them, they were all released, citing lack of proof. It was the judgment says that it is a spontaneous event. There was no conspiracy or there was no incitement to violence or anything. It was a spontaneous event by an uncontrolled mob. Okay, so in fact there was no convictions. Nobody is convicted or punished in the criminal case. That is the criminal side. All right. So again, a lot of questions can be pointed out at the judgment. People criticize the judgment. In fact, yeah, it should be criticized. So there is an accusation that Supreme Court is bending before the government these days. Camera there is an accusation that Supreme Court has become very pliable in the recent days. All these criticisms are definitely there. But when it comes to the civil dispute, what was a civil dispute? The civil dispute was, as I told you, between two private parties. It's between one Hindu group and the other Muslim group. I don't remember the name of the parties. Okay, it was between two private parties. The Hindu group was representing the deity Ram, Lalla, God Ram, versus Waqf board. So all mosque lands, all the lands where mosques stand, no, all that is controlled by the Waqf board of Muslims. Okay, so these two parties, they involved in this litigation, and when it comes to any civil disputes, okay, see, if I have a land and my house is constructed there, and I've been living here for quite some time, suddenly my neighbor comes, he demolishes my house. Okay, I go to a court, he demolishes my house. Now I go to a court. I have a proof that I had my land here. My house was actually standing there. I was residing there. I have my proof. So what will the court do? What do you think the court will do? If I go to a civil court, so who will be given the ownership of possession over the land? My neighbor comes, he demolishes my house, he comes and sits over this land. Okay, he comes and sits over the land. So if I go to the court, what will the court do? Will it give verdict in my favor, or will it give verdict in the favor of my neighbor? Who will be decided as the owner of the land? In my favor. But what Supreme Court has done is, the Supreme Court has given the land to my neighbor. It said to me, you don't please claim this land because your neighbors here, they don't like you. But in some other locality, I'll give you 5 times the bigger land. Okay, I'll give you very big land in the neighboring area. But please don't claim this land. Supreme Court's work is not to bargain in favor of my neighbor. It is not to negotiate between us. Supreme Court's work is to render what is justice has to be given. It's my property. I have been possessing that property. I have been occupying that property. So I am the rightful claimant to that property. Why should my neighbor be given the property? That is an obvious question that you will ask. But Supreme Court says, please, no. Even though you have the possession, ownership, you have proof of photograph that you have been living there, but if you say come here, there will be a law and order problem. There will be law and order problem, and there will be too much of problems. I want to put an end to the problem. I don't want you to become a problem maker. So please shift to a different locality. I'll give you very big land. Okay, this is what actually happened in Babri Masjid demolition case. Because Article 142 gives this power, Supreme Court can pass any kind of an order. Because if you go by CPC, if you go by Civil Procedure Code, the law clearly says how ownership will be decided. Ownership over a piece of land will be decided on 2 bases. One is possession, the other one is title. Title is I should have a document in my name. Next thing is I should actually be living on that land. Even though I have a name and for 100 years I am living somewhere else, somebody else is living there for 100 years, I cannot claim ownership over that piece of land. Okay, so these are the essential principles. Title and ownership is the basis of deciding ownership as per Indian civil laws. So violating all the principles of CPC, nothing. Whatever I feel is justice, I will be doing it. So this is how Supreme Court has interpreted Article 142 to give itself the powers. Supreme Court's work is to respect the law made by the Parliament, law-making body, to do as per the law. That is the work of Supreme Court. But Supreme Court is very adventurous these days, so it has started creating its own versions of justice. That is exactly what happened in Babri Masjid case. Okay. Yes, your question is right. Why would law and order problem be the problem of Supreme Court, sir? Isn't it the issue of executive? Correct. Ideally, the Supreme Court would have ordered the executive, you ensure protection for the mosque that will be constructed here. Okay. But let me also tell you, even though I might be speaking as if I'm very morally, I'm right, it's only when you sit in the seat, you will understand these issues and dilemmas. Okay. What otherwise could have happened? You tell me. Possession was in the hands of both Hindus and Muslims for a long time, correct? So half of the periphery of that one side of that mosque was already in use by the Hindus. Since 1930s or 40s, someone had come and they had kept some statues of Lord Ram there, and they had started worshipping. So a part of that mosque was anyway, it was used by Hindus. So Hindus also had possession over this piece of land. At the same time, Muslims also had possession. This cannot be refused. While this is being accepted, now this is being refused. Why? because the Supreme Court feels that the reality is very hard. If land would have been given Hindus 50%, Muslim 50%, you build a temple here, you will construct a mosque here. And the Supreme Court passes an order. Security should be ensured. Police forces should take enough steps to protect the mosque from now onwards. Okay. What do you think would have been the consequence of this kind of an order, this kind of a judgment? If the Supreme Court would have given this kind of a judgment, what could have happened? Hmm? Tell me. Yes, communal tensions. Another Babri Masjid. That is, when BJP was not even in power in 92, an incident like Babri Masjid demolition happened. Today, BJP is in power in both center and in the state. So imagine what else can happen if that would have been the situation. So that is why the judges, they did not want to take this blame. They did not want to take the blood on their hands. That is why they have also realized that Muslims might not actually protest against this. It was a long series of negotiations that actually happened. So the pulse of Muslims was also that, okay, let's forget this issue and let's move on in life. Okay, so that was the reality. Though law is something, in 25 years, 30 years, lot of things have changed in this country. So the reality is something, law is something. Okay, this is the dilemma that you will actually face when you work on the field. Okay, law will say something, but the real situation will be something else. If you go strict as per law, you will end up creating more problems. The law itself can become a problem for you. There are many such incidents which I have faced. So I'm sure the Supreme Court judges would have also faced this kind of a dilemma. It would have been easy to go by the law and give a verdict 50-50% for both. That would have made Supreme Court as a great champion of justice, no doubt about that. But the consequences that will follow may be too harsh. So justice can become problematic. So that is the reality of human societies. We don't live in computer algorithm driven models. We live in a place full of emotions, right? There can be anything that can whip up emotions at any point of time. All laws, all security arrangements, forces will only help up to a certain extent. After that, certain governmental institutions would even find themselves helpless. So anyway, this is what could have actually happened, and the Supreme Court judges thought that it's better to come up with an amicable solution rather than once again prolonging this dispute again and again and again. Maybe that's why they took this recourse to Article 142, and none of the Islamic organizations, many of them even welcomed the judgment. They felt that it is a relief for us. They felt that we are not even going to review against the orders of Supreme Court. We just respect it and we are happy with that. So just for the purpose of taking my class, I'm saying that this is not correct. Supreme Court should not have done. It is just for the purpose of taking class. Okay, so as to point out how big the power of Supreme Court is. But the reality is something different. Real decision making is something different. Okay, it's not a theoretical thing that you write on the piece of paper. It is practically putting things to work, which can have an impact on a lot of interests. So okay, anyway, so this is the use of Article 142. But what is the problem here? The problem here is Supreme Court says you will be given 5 acres of land in a different place. Okay, I'm saying that this decision of Supreme Court is an infringement into the domain of the legislature. How? Why do you think so? What I'm saying is, sir, there's a lag in video streaming. Is it from your end? Okay, is it so? Is there a lag in video? What about others? Is there any lag in video streaming for everybody else also? Yes, yes. Video lag இருக்கு போல இருக்கு பாருங்க. இப்போ வந்துருச்சா கரெக்டா? Okay. How about now? Is it fine? Can I proceed? Or do you guys still face the problem? Uh, someone says no, someone says yes. Are you saying that the video is clear? Can I proceed further? Is the video transmission clear, uninterrupted? And can we proceed further? It is still lagging. Lag இருக்கு போல பாருங்க என்னன்னு.
You are in the Zoom meeting now. This meeting is being recorded.
Okay. Okay. How can executive and legislature counter judicial overreach if it happens under Article 142? They cannot counter anything. Maybe they can create one more law and nullify the effect of the judgment. That can be done. As per the existing laws, Supreme Court has given a judgment. But legislature can pass a law and it can counter, it can nullify the effect of the judgment. That can be done. That's one way of how to counter excesses of the judiciary. And the best way to counter, to give a warning to the judiciary, is just to pass a removal motion against the judge. That is the best way to do it. Okay. So, yes, I asked you a question. The question is, how can this order of the judiciary become a problem to the legislature? Tell me. I'm saying this is a problem for the legislature. Supreme Court ordering, give them 5 acres of land in that particular area for constructing a mosque. That is a problem for the legislature. Tell me why. No, it's not. It's nothing to do with vote bank. No, 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 no. Execution is very correct answer. Very correct. Where will they find that land? That is the correct answer. Allotting land will be difficult because of ownership issues, right? See, each state will have its own land reform acts. The state where I was working, we had a act called as Odisha Land Reforms Act. Okay, so it is this act which will talk about what kind of land should be allotted, because land is of multiple categories. You have very fertile lands, you have barren lands, you have stony lands, you have lands with running water irrigational facilities, you have lands which are slopy in nature. Different categories of lands are there. It is based on the topography. The purpose for which a land can be put into use will be decided. So these are the work of legislature. Legislature will appoint a committee. They will submit their report. Based on that report, what land is suited for what purpose. And already we don't have enough land after land redistribution to people, after reserving various lands for industrial development projects. Land is a very, very scarce resource today in this country. If that is the case, and Supreme Court is ordering, give them land, it becomes a problem because the executive cannot act without a law. Okay, and the law should give some clear principles that it is on this principle the land should be allotted. Okay, so it is a practical difficulty now for executive and legislature to give effect to this provision, effect to the judgment of Supreme Court. Okay, so this is all I need to discuss about Article 142. But there is also something good about Article 142. The way Article 142 was used in Bhopal gas tragedy to compensate the gas tragedy victims. So, are you aware of this Bhopal gas tragedy? There is a company called as Union Carbide, which was operating a methyl isocyanide manufacturing production plant in Bhopal. Okay, very poisonous gas. It is used for industrial applications. So, on one day, there was a leakage of the gas, and people in that locality were all killed, and many people got blinded. Lot of fatal complications slowly arose, and there was a criminal case that was going against, the government had filed against the company, and the company was asked to shut down its operations. All that is fine. But at that point of time, in India, we did not have a strong law like the Western countries, where polluter pays principle was not actually there. In 1980s and all, we did not really care about all those things. People are disposable. If they die, who cares about them? That was our idea then. So there was no strong law to compensate victims for the damage that has actually happened to them. So without a law, the company will always say that I'm not bound by the law. The law was not there, so I'm not bound to pay any compensation. But Supreme Court ordered under Article 142, whether a law or not is immaterial. I have the power to do complete justice. I'm ordering you, you pay this much amount of compensation to these victims. Okay, only then your plant will be allowed to be sold off to others. Or so this kind of a benefit was given to a lot of victims by the Supreme Court using its powers under Article 142. So discretion is always a double-edged sword. Okay, discretion. These are all discretion of the judges to make use of it in whatever they want. It can be used for good purposes also. It can be, I mean, till now, I would say Supreme Court has only used for good purposes. It has never exceeded the limits. But there is always a potential of overreach. There is always a potential of interference of other organs, right? So this is it. That is all about Article 142. There is nothing more to be discussed. So Article 142 cannot be amended. Of course, it can be amended. Why not? But what will you amend it as? What will you amend it? As I told you, it has never become a problem. Maybe the day it becomes a problem for legislature and executive, maybe then it can be amended and very clear wordings will be added. It is only with respect to governing the internal procedures of judiciary. Maybe that phrase can be added. But till date, that's why I say Supreme Court has never done something which is irritative or which is interfering in the matters of legislature or executive. Every institution knows its own limits. Okay, so India is such a beautiful democracy that is functioning, the best democracy we can ever have. So all three organs really working well. Yes, of course, there are problems which comes in now and then when judges become pliable, when judges become pliant to members of executive or judiciary or legislature. But you cannot paint all the judges with the same color. There will always be judges who are better. Okay, and it's okay. So we are just going on. Okay, just because someone brought in an issue of this dilemma. Okay, why not order the executive and legislature, which is the correct answer from the legal standpoint. I'll just give you a dilemma which I had during my days in the service, and this can be a good case study for you in your ethics paper also. Okay, so I'll just give you a dilemma. Maybe you can just think on it. It's a simple thing. So in my early days of my career, initial first posting, so I was posted as a municipal commissioner. Okay, it's a municipality for which I was posted as a municipal commissioner. So a huge amount of money comes in municipalities. You can build a lot of roads inside the municipality area. You can take care of garbage function, sewage issues, all that. A lot of money comes in. So if you see how decisions are taken in municipalities, you have councillors, correct? Councillors are the elected politicians. So they will decide in the municipality meeting what kind of works need to be taken up in municipality. So before I had taken charge under my predecessor, uh, during that time the council had decided that we will construct a road from point A to point B. The road is for 300 meters length. A 300-meter cement concrete road for a total cost of 40 lakhs will be constructed out of the money that is available in the hands of municipality. Okay. So instead of building this road, last year, just 2 years back, they had already laid a road here in the stretch. That road is in good condition. Okay, the reason why they had chosen this point as if a road is necessary is they can show account as if road has been built here. And in reality, this 40 lakhs was not used to build the road here. There will be just so many projects which will be implemented in a municipality. So as a commissioner, I cannot go and verify each and every project. The legal mandate is at least 10% of the total works I should personally go and visit, be satisfied, and I should pass the bill. For other 90% of the work, I don't actually have to go and inspect. I can just sit from my office and I can pass the bills. So when on one of my inspections, I used to visit a lot of projects. Whenever I go, maybe 30-40% I would have visited during my tenure. Okay, so this particular road, surprisingly, this was one of the projects which I decided that I'll go and just visit because it's 40 lakhs, huge amount of money. So let me go and visit. So when I went there, there was no road. No road was laid out. And the proper file was opened face by face, each at every 2 months, face by face. Whenever you will not clear the entire bill in one settlement. Okay, the bill will be cleared in 2-3 settlements. After 3 months of starting the work, 15 lakhs will be given. After 3 months, another 20 lakhs will be given. It is paid in installments. As and then, when the work gets finished, money will be released to the contractor. So when I went to the spot, I was surprised. The work was not even taken up. It was not even done. Okay, but already file is all ready for me to just pass and give my signature. And in reality, what was that money utilized for? The money was utilized. There is an orphanage. Okay, there is an orphanage, and to lay an orphanage, the entire floor of the orphanage was in a very bad condition, fully muddy. Whenever rain comes, children get affected. Nobody can come in, come out. There was a problem. So what councillors had decided is they will spend this 40 lakhs for the betterment of this orphanage. Okay, they just installed all the CC cement concrete roads and they beautified this orphanage. And now they come to me and they say that, sir, we have not cheated the money. I have only used it for a noble purpose. It's our community children who are living there. 100 young children are there. They have a problem. They're not able to come out, go in, get in. This is the real problem, sir. That is why we have spent this money and we are showing this as a bill. Okay. So don't ask me about what I had done or what I would be doing. This is a question for you to think upon. This is a case study for your paper 4. As a municipal commissioner, what would be your course of action if this is a situation that is given, and if it is asked? Okay, so tell me, why don't they show it as a renovation of orphanage? They cannot. It is a private orphanage. You cannot spend public money for a private beautification purpose. It's a private orphanage. It's not run by government or anything. Okay, so you cannot spend public money for any private works. You can only spend it for public works. So what would be your course of action? This is the kind of dilemma that you will face on a daily basis in civil services. So what is your answer? The money is spent on good purpose only, so I will grant it. Okay. Sir, I let them use it. Okay. See, I'm not judgmental or anything here. I'm just asking you, It's not in your duty to pass the bill, but by virtue it's right, and the end result of public good is achieved. 2 versus 1, therefore grant. Okay. So will you be writing this as an answer in the examination? Because what is the see? You are looking at from the objective of nobility of the purpose. You are looking considering the cases here. Okay, but my uh, concern here is, what are the risks associated here? Tell me, what are the problems associated with this kind of an approach? When you say that I would allow them to use it in this manner, what are the problems associated? I would take action on them because they may use for their own purpose in the future. That is very correct. This is a precedent that is going to be set. Once you allow them to do this, next they will not stop with the orphanage. Next, the chairperson of the mayor of that, the chairperson of the municipality, they have a farmhouse. We used to hold all public meetings there, so it is only used for public purpose. So why don't we beautify my farmhouse? That will be the next demand. Slowly, a culture of non-obedience to law will set in, and you are a part and parcel of that process. You are leading to a decay of the institutions. Yes, superiors will inspect and they will ask you. Of course, there is always a legal risk that you are having. Okay, at any point of time today, these counselors will come and ask you, sir, it is for a noble purpose, sir, why don't you do it, sir? Tomorrow they will file a RTI and they'll ask, I don't see a new road here. Why? Where is the road? Maybe you would have see, in your course of your duties, you will definitely encounter into a conflicts with a lot of people. You will create a lot of enemies than friends in the services. That's the truth. So the same guy who yesterday had begged you to allow the bill to be passed, now he's the same guy who will file an RTA, and once he gets the money, he will file an RTA and he'll question you. Where is the so are you creating a fake bill? So how dare you do that? So you are accused of corruption. He will write to Chief Minister, CBI, Prime Minister. All such letters will be sent after that. Okay. And again, when you say that it is used for noble purpose, who are you to decide on whether this purpose is noble or not? It is a government which has already decided what all purposes are good and noble purposes. What are the good and noble purposes? Laying roads for the use of public, laying street lights for the use of convenience of the public. These are the noble and good purposes which the government has already identified. Okay, so who are those councillors to decide what is good and what is not good? Council has been given powers to decide among the public purposes what can be, for what money can be spent, right? So anyway, maybe I'll consult with my senior. See, when you write this point, no, I'll consult with my senior in the answer. You know what kind of an impression that will get? That will give, as if you are non-decisive, you are not brave enough. You would want to put your responsibility on somebody else's shoulders. And I'll tell you, once you consult with the senior officers, nobody will be ready to take responsibility. They will say, you do what is necessary to be done. This is the answer that they will give, okay? They will never give it in writing. Yes, please go ahead and pass the bill. That will not be put in writing. They will just give a WhatsApp call, so that the call can also not be recorded. They'll give a WhatsApp call and they'll say, you do as per what the situation demands. Okay, so indirectly they'll say, it's okay, pass the bill. Why create problems? So this option of consulting with the seniors, maybe you can clarify it. Maybe there are certain provisions in the law which can probably allow such kind of deviations if it is done for any public purposes. I will first find out if there are alternative provisions or not, if there are alternative purposes for which this money can be well spent or not. So since and to ascertain if there are any other alternative provisions in law, I would get a word from my senior. So that shows that you are still law abiding, but you are exploring every possible alternative so as to approve this project. Okay, so you should never go against the law as a bureaucrat. You can the minute you violate the law, it's a threat to you, and nobody will come to save you at the end of the day. Okay, you have to save yourself in bureaucracy. So, and one of the seniors gave me a very good advice when I entered into bureaucracy. The advice was, you take care of law and the law will take care of you, which is very true. Okay, I've seen people get affected because of not following the law. So always go in accordance with the law. Okay, the law may be constraining, the law may be binding you at times, but it is for your safety. So I'm not saying which is good and which is bad. I'm not saying this approach is good, that approach is bad. That is not my intention. My intention is to point out, when you have this question in the examination, even the examiner himself is not expecting you to pass a judgment on what is good and what is bad. They are just asking you to explore what is the consequences of doing this act, what is the consequences of doing this act, what are the consequences on myself as an officer, what is the consequence on the institution of municipal commissioner, on what are the consequences on what do I say, on the authority of law. Law is getting weakened by non-observance of law, right? So that is what is expected out of a bureaucrat in out of you in this ethics paper. You just have to think and come up with as many dilemmas as possible. If I do this, this will happen. If I do this, and finally you give your judgment, and that judgment should be based on the side of law. It should never be seen to be completely opposite to the law. That would display a disregard for law. A person who has a disregard for law can never be a civil servant. You can be a politician, but you cannot be a civil servant. Okay, so this is just one example of a real life dilemma. So many of the dilemmas that you face as an officer is with respect to financial matters. These kind of matters, a lot of dilemmas you will be regularly facing, and there are other matters also dealing with law and order and so many other kind of issues. Maybe we'll speak about those other dilemmas in some other class. So let's continue. I'll continue with the next topic. So this is all that needs to be discussed about powers of Supreme Court. I'll discuss about two concepts, what are called as judicial review and activism. So what is this judicial review? Anybody? Can somebody tell me what is this judicial review? And tell me if the power of judicial review is mentioned in the Constitution. Do you find the power of judicial review which is mentioned directly in the Constitution? To look into the constitutionality of any laws passed by legislature. Okay. Article 13, analyzing law, power of Supreme Court to check the constitutionality of a law. So you all seem to say that judicial review is a procedure, it is a method for the judiciary to exercise a check and balance on the legislature. Is this how you mean to say? Does it mean that judicial review cannot be exercised on an executive? So you seem to just say judicial review means it is what is done under Article 13. Article 13 talks about a review of laws made by Parliament, whether it is constitutional or not. Okay. What is not mentioned in the Constitution? Article 13 talks about it clearly. Laws will be declared as void if it violates fundamental rights under this particular provisions. So what more needs to be given? That is the explicit. Maybe the word judicial review is not mentioned, but the provisions regarding judicial review is found in the Constitution. Constitution grants Supreme Court the power to review the constitutionality of any laws. Okay. So what is your answer? Can judiciary review executive acts or not? Acts are of two types. Acts are legislative acts, then you have executive acts. Legislative acts is the law, executive acts is the actions taken by the police force. They come and arrest you. That is the executive act. Yes, even executive acts can also be reviewed by the judiciary, whether it is constitutionally correct or not. If a policeman comes and arrests me, it's constitutionally wrong. Without a law, if he is arresting me, so it means that he is depriving me of my fundamental rights. Hence, his executive act should be now declared as null and void. Okay. So judicial review extends to both legislature as well as executive. It is the power of judiciary to examine the constitutionality of a legislative enactment and the constitutionality of an executive action. How Constitution ensures these powers by means of Article 13 to check for the validity of legislative enactments. Constitution provides judiciary powers under Article 226(32), the writ jurisdiction powers to look into the correctness of executive enactments. So that is how judiciary gets all these powers. Okay. So what does the judiciary? So what you have to discuss here is two concepts called as procedure established by law and due process of law. What is the constitutionally given provision? So do you know the difference between these two terms, procedure established by law and due process of law? Do you know the difference between these two aspects, these two concepts? Yes or no? So should I explain it to you? Yes. Okay. I mean, you. Okay. Explain. Okay. See, in Britain, the procedure followed by judiciary is procedure established by law. In America, the judicial practice is following a doctrine, following a practice called as due process of law. I'll bring out what is the difference between the two. So let's say this is a system that is followed in UK, this is in USA, and Indian constitution makers, they wanted our Indian judiciary to be modeled on the lines of UK. So that is why this is the term that is used in the constitution. Where is it? Where do you find this term? Procedure established by law. Where do you actually find this term? In what part of the constitution do you find this term being used? Very correct. Article 21. What does Article 21? What does Article 21 say? It's not Article 14, it's Article 21. What does Article 21 say? It's not right to life. That is what you will get when you read Article 21 as given in Lakshmikant. Okay, actual constitution does not say Article 21 means right to life. That is not how the actual constitution talks about. When you read the actual constitution, the idea that you get is, yes, actual constitution says no person shall be deprived of his or her right to life and liberty except under a procedure established by law. Okay. So we find this principle enshrined in the Indian constitution. So what is this principle, sir? This principle is to give judiciary a very limited power. But this principle is to give judiciary wide interpretation power. In Britain, can I say that in Britain, constitution is supreme? Can I say in Britain, constitution is supreme? Will you accept that? No. Because in Britain it is very clear, Parliament is the sovereign body. Parliament is all in all. What Parliament says, that is the correct, that is the truth, correct? So that is why they have a very limited role for judiciary. Judiciary cannot look whether a parliamentary law is correct or not. Judiciary in Britain cannot look whether the parliament law that makes is whether it is correct or not. It cannot go into that. Even if the parliament makes a very harsh law, judiciary should just accept and work as per the law. So let's say the parliament makes a law. If somebody somebody commits adultery, okay, if someone commits adultery, the person shall be put to death. Okay, do you know what is adultery? Yes or no? I'm not going to ask you to define it. I'm okay. Extramarital affairs. Uh, Extramarital affairs is actually not adultery. Adultery is when a man, see, I'm a man and I'm married, and if I have a relationship with a girl who is not married, that cannot come under the definition of adultery. But if I have a relationship with a woman who is married to another man, that relationship can be called as adultery. So extramarital affair is one form of adultery, but it is not exactly adultery. Okay. So and do you know that adultery is a crime as per Indian law? Do you know that? Only recently it has been decriminalized. For a long time, adultery was a crime in India. Yeah, that is discrimination, no doubt. And do you know what is the reason for such a definition for adultery? Do you know what is the reason for such a definition for adultery? If I have a relationship with a woman who is married to another man, I can even be put behind bars. So it's a criminal offense. It was a criminal offense in India. And do you know what is the reason for that? The reason is, if I have a relationship with her and a son is born, okay, and an offspring is born, that's very correct. Women being a property of someone else, that's the idea. That woman is a property of that man. So I am depriving that man of his property. So I am stealing his property. So that is the idea with which adultery was a criminal offense for so long. Only very recently it has been decriminalized. Okay. Anyway, so adultery, if someone, let's say, the punishment for adultery is death. That is the law that is made in Britain. Okay. So in Britain, if Parliament makes such a law, judiciary cannot question why this is too harsh. Adultery is such a simple matter, and why would you want to give death sentence? So Parliament's action is not correct. The parliamentary law itself is bad. Such a kind of a decision, judiciary cannot do in UK, because Parliament is supreme, Parliament is sovereign. So judiciary has a very limited role. What is that role? Whether the man had really committed adultery or not has to be examined. Without following a procedure to find his guilt, he should not be given death punishment. Only that judiciary can ensure. So if the policeman comes and if he himself arrests the man, he goes and fires at him in a police station, that is a process that was done against the law, because the law says that he should be produced before the magistrate, he should be heard before the court, and then he should be hanged. Okay, that is what law says. But the policeman had taken law in his own hands. He has just fired at him and he had killed him. So executive act is not in accordance with the legislature, with the legislation. Okay, this is what is called as a narrow scope of review, narrow scope of judicial review. So in Britain, this is how the courts would function. The courts would work with a very limited power of review. The review is only limited to reviewing the executive acts. Because Parliament is supreme, whatever Parliament says is right, the law can never be questioned. But in US, that is not the concept. In US, whether the law is only correct in the first place or not. In US, even no institution is considered to be supreme. There, the Constitution is considered to be above all the other three institutions. So that is why, whether in US the system, the way the courts have functioned is, even if the legislature makes a law, the law cannot be trusted, because legislature is after all a majoritarian body. A majoritarian body cannot be always trusted to make laws in the interest of the entire section of the people, right? So that is why in USA, even the laws made by the legislature can be questioned on various grounds by the judiciary. On what grounds? On grounds of reasonableness, on grounds of fairness, on grounds of proportionality. That is, for this punishment, for this crime, is the punishment proportional? Death is not proportional to a a crime like spitting on in public places. No relationship, no proportion, it's completely disproportionate. The procedure that has to be followed, the investigation that needs to be followed as per the law, is it a fair process or not? Okay. So this is how the judicial practice in USA had evolved, and when you read various sources on the internet, you will come across a lot of cases. Madbury versus Madison's case. That was the first time when the judiciary in USA started this process of looking into the correctness of the law itself. You will come across a lot of case laws. If you have time, you go through your various resources on the internet and find them, read them. But I do not have time, in the sense we have only 20 classes or 22 classes to complete the entire polity part 2. Already I think this is the 10th class or something which is going on. So I cannot discuss about various aspects of how this concept evolved and all these things that would make me waste my time, so which I should be spending on other topics relevant for our exams. Okay, so this is how the judicial systems in both countries function. And in India, the constitution makers did not want to give judiciary a wide power as how it was given in USA. So that is why a narrow power of judicial review was actually kept in the constitution. But with time, our Indian judiciary itself evolved in this direction. Even though the constitution till date it says procedure established by law, but Indian judiciary, because of so many issues what had happened, that will be the next part of our lecture. I mean, we'll take a short break and we'll discuss emergence of judicial activism and emergence of basic structure doctrine. That is something that we'll discuss in the next part of our lecture. Okay, our constitution says procedure established by law, but Indian judiciary itself has started becoming more and more proactive like the US judiciary. So in practice, it's a due process of law method that is being followed. So whatever law is made by the parliament, even if it is a constitutional amendment, the validity of the constitutional amendment itself will be questioned by the Indian judiciary. Okay, so because we are moving, our Indian judiciary has moved on to a wider way of interpreting a law. So I'll just stop here and take a short break, for 5 minutes, then we'll continue. Still, or otherwise you can unmute yourself. But otherwise you can mute yourself if you're not going to speak anything. Mute பண்ணிருங்க அஸ்வின். பண்ணிட்டீங்களா? Okay. Okay, let's continue. So this is the power of review, to look into the validity of a law, to look into the validity of an act. Constitution has provisions which gives the power in the hands of judiciary to review the validity of executive and legislative acts. Though the constitution makers had given a narrow scope of judicial review, but judiciary with time had expanded its scope of judicial review in a series of litigations in various cases. So are you aware of, I'm sure you would have read about it during your fundamental rights discussions. In what case has this concept of due process of law was recognized as a part of the judicial process by the judiciary? In what was that landmark judgment which clearly spelled out that we in India, we are going to follow due process of law, even though it is given in constitution as procedure established by law? Are you aware of the case? It is not Keshavananda Bharati case. No. It is the Menaka Gandhi case. That is correct. It is not in Keshavananda Bharati judgment. So let me discuss with you something about judicial activism. So what is your opinion on judicial activism? Is it good or is it bad? Is it needed or is it not necessary? Of course, I'll discuss what is judicial activism. But if you have already heard this word, I just want to know what is your opinion on judicial activism? Is it necessary? Is it good? It is needed. Okay, it is needed. Okay. So judicial activism, in my opinion, is always good. It is only when it goes to the extent of judicial overreach, or it can even be, there's a term can be used which is called as judicial adventurism. So this is the worst thing that can happen. This should not be there, but judicial activism should always be there. So what is your understanding of judicial activism? How would you call a judiciary to be activist judiciary? What do you understand by judicial activism? And tell me, what is the reason why judicial activism has come in India? What do you think is the reason for judicial activism in India? Yes. What is your answer? Why do you think judicial activism has developed in India? They actively involve in promotion of social justice, correct? Emergency, no, emergency is not the reason. Infringement on fundamental rights of citizens. But if executive infringes on fundamental rights, you already have provisions. It can be struck down. So you don't have to be an activist judiciary to look into, to nullify actions that violate fundamental rights. Instability of the government, no. In the larger public interest, sometimes Supreme Court has to act to deliver instantaneous justice. Okay, I can accept it. But what I would say is there are constitutional provisions which actually allows judicial activism. What is that? Article 21. This is the main reason why we have the concept of judicial activism in India. The only reason we have a very active judiciary, because judicial activism is always done on the pretext of protecting the life and the liberty of the citizens. The Constitution, it says, right? This is what the Constitution says. Yeah, definitely. Article 142 can also be claimed as a reason for judicial activism. Correct. So Article 21 is the main reason for emergence of judicial activism in India. This is what the Constitution says. That is, what it says is, The executive or the legislature should not do anything that can take away the liberty or life of a person. Okay, except under a procedure established by law. By a law, if you're taking the life, then it's okay. A death sentence is as per a law called as Indian Penal Code. So, as per, if a law prescribes a procedure to take away the life or to detain a person, you have a lot of detention laws. So then it is all okay. But without a law, no person shall be deprived of his right to life and liberty. That is Article 21. Do you think it is positive or is it negative? What is the tone of Article 21? Is it positive in nature or is it negative in nature? Do you know what is a positive interpretation and what is a negative interpretation? So, what is your opinion on this provision? Is it positive in nature or is it negative in nature? It is positive. No, it's not positive. Positive means something which places a duty on the state to perform is called as a positive character of a law. Something which restricts the activity of the state is negative in character. Okay, so the actual tone of Article 21 is negative. That is, it prevents the state from doing anything that can affect the life and liberty. It is to stop the state from doing any action that can take away the life and liberty of a common man. It is this tone that is inherent in Article 21. It's not a positive act. So, for a long time, this was the only way of interpreting Article 21. That is, the state should not do anything. And why long time? Because for a long time, we did not have this concept of welfare state. Earlier, the idea was, this is how the conception of the state also gradually moves on. First, the role of government is to only protect people. It is to ensure law and order. It is to protect life and property. Just give me a minute. Okay, so the state until the 1970s, world over, the orientation was not about. So today, do you think the government has to actually take care of the old people, sick people, beggars, prostitutes? Do you think the government should take care of these people? Yes or no? Do you think the government should take care of homeless people? Do you think the government should take care of orphans? Yes or no? Yes. That is why we have all such protective provisions. We have old age pension, we have widow pensions, we have social security measures, right? And do you know and do you know that disabled people have a reservation in public employment? Of course, you know, because you're preparing for UPSC, disabled quota is there. If you have physical issues, then you can avail disabled quota and you can get into civil services, right? So this principle of reservation for disabled, do you know when it was introduced? You'll be surprised that it was introduced only in the 1990s. 40 years after independence, disabled people got a right to compete within themselves for competitive examinations. In today's world, it might appear to be so cruel that disabled people, how can you ask a disabled people to run the same race as that of a normal candidate? So, but that was how. This is because today there are a lot of expectations on the state. On the government is expected to take care of a lot of needs of the people. Even if to wash clothes in the house, we expect the government to give us washing machines, right? That is the expectation today, because today we live in this era. But when we got independence, we were in this era. This is all considered to be not an obligation of the state. These are considered to be some extra measures. If the state is capable, let them do it. When we got independence, at that time, the global thought process about what should a government do is only this much. It is to take care of life and property of the citizens. This idea is a modern day evolution. earlier idea about the government is it has to just protect us from enemies, that's all. So in that kind of a scenario, the state, there was no other, in a police state, the state is expected to not do something that can take away my freedom, right? That is why you had this wording in the constitution, because this constitution was made in the era where the idea about the state is police state. At that time, state should not do anything to take my life and liberty. That was the idea then. But slowly with time, what happens is, as the expectations on the state also increases, as you move on slowly to this welfare idea about the state, so then now courts feel that Article 21 should be interpreted in a positive manner. Okay, let me even simplify it for you. Let me give another example. Policeman coming and arresting me and killing me. Is it a violation of Article 21? Yes or no? It is. So it is an act of commission of violence against. Policeman has committed an act of violence against me, so he has to be punished as per article, because he has violated Article 21. But slowly, I'll give you another example. So gradually industrialization also starts taking place in India. Let's say this is a village, okay, a village, and you have all polluting industries surrounding the village. So all the pollutants, effluents are released in the water bodies near the village, okay? And because of that, people are going to get cancer and they're going to die. So can I blame the state for this? Can I blame the government? Yes or no? The government has not done anything. The government has not done anything to take away your life or liberty. You are just allowed to live. Government is not interfering you with government has not deprived your life or liberty or anything. Okay, when in the earlier era, there was a very narrow understanding of life. Life means just remaining, just existing in this world. That is all that was understood as the meaning of the word life. Okay, you have to survive. Whether you live a dignified life or not, that is all immaterial. You have to just live like any other animal. If you're alive, it means that your right to life is not violated. But slowly, what does life mean? The word life, how do you understand about it? So that was slowly expanded by judiciary in a series of cases. Lot of cases have gone into this expansion of understanding of the word life. Okay, so in this period, can I not say the government, by not acting against the industries, is going to deprive me of my life? Maybe today I am alive, but tomorrow definitely I am going to get cancer. In 1 year, I am going to definitely get cancer. If the state does not interfere, the government does not stop these industries, I am going to die. So government, by its act of omission, omission is the government is failing to act. By an act of omission, my right to life and liberty can also be affected. This is the new interpretation of Article 21. So the government, by not acting, can take away my life. So it means that government, by its inaction, can also affect my Article 21. So what happens now? Now the Supreme Court gives an order. Do this act. You are failing to act. Because of failure to act, you are leading to the violation of Article 21 of this private citizen. So go and stop these polluting industries. Shift these industries from this place to some other place. It is this idea that the word life can be understood in a better way. It can be understood in an even broader way. It is with the changing idea and understanding of the word life, judiciary has interpreted Article 21 in a positive manner. Okay, it is this kind of an interpretation of the word life and liberty in Article 21 which has come to be called as activism. Okay, by interpreting it, definitely the judiciary has to pass orders. It will pass orders. Go and give protection to widows. Go and give protection to homeless people. Provide them shelter during winter months. There is a lot of monkey menace in Delhi. People are getting bitten by monkeys. So shift these monkeys from here to there. There's a lot of pollution in Delhi in the surrounding areas because of stubble burning. So I'm ordering the government to stop stubble burning. If it's only if only if stubble burning is stopped, air quality will increase and people will have a clean air to breathe. Only then they will have a life. Otherwise, they will only be merely surviving. Okay. So, what life and liberty means? This interpretation has undergone a change. Slowly with time, interpretation of the word life and liberty has greatly changed with a series of cases. So the first starting point for a different wider interpretation of life was a case called as Husainara Khatun versus state of Bihar. This case, what was that case? The prison inmates who are lodged in the prison in Bihar, they are just chained like animals. They are not properly given food. They are subject to torture. So, yes, they are kept alive. That's all. So the state pleads, the state makes its argument. I have not killed him. I have not taken away his life. Then why? How can you say that his fundamental right is violated? Court says, no, no, no. You have to treat him like a human being. Mere physical existence, mere physical animal existence would not mean life. A person should have a dignity in the way he is treated. Okay, so it is right to be treated with dignity. So that is added in one of the case. There is another case called as Olga Tellis. Olga Tellis versus Bombay Municipal Commissioner. It is in that particular case, court says a person, just if he is alive, it doesn't mean that he is alive. He should have avenues to provide for himself. He cannot be made to be dependent on others. So what do we mean by he should have avenues for survival? He should have a livelihood opportunities. So right to livelihood was added. It's only when he has a right, when he has a livelihood, he will be able to earn his money and he can have an independent existence. Otherwise, he is going to be perpetually dependent on someone. So that is not his right to life. So that is why right to livelihood was added as an interpretation of what life means. Okay. Similarly, the case of education, I forgot the name of that case law. Even right to education was added as a part of the meaning of the word life. What life would mean? Life means the right to be educated. It's only if you're educated, you will be able to survive in this world. You will be able to compete with others in the world. So, right to education was interpreted as the meaning under hidden in the word life. Then it was enacted as a law. So, judiciary first interprets right to education as a part of Article 21. Then Parliament responds by bringing in an amendment to Article 21A. It adds a fundamental right to education. Okay. Supreme Court interprets right to livelihood. So Parliament responds by bringing Mahatma Gandhi National Rural Employment Guarantee Scheme. Supreme Court interprets right life means a safe workplace in the safe workplace free of sexual harassment. So Vishaka guidelines. It's only when women have the safety and security and freedom to work in their workplaces without any sexual interference from men, sexual harassment from men. Only such a life can be considered as a proper dignified life. So Supreme Court gives a new interpretation to the word life by saying access to a safe, sexual harassment free environment is also a part of life. Then immediately Parliament responds by creating an act, Prevention of Sexual Harassment at Workplace Act or something. Okay. Now tell me, do you think judicial activism is bad? This is what is called as activism. Judicial activism is about creatively reinterpreting the law in the light of the needs of the society. Because law is, after all, a verbal, textual document. But more energy, more purpose can be given to that law by creatively interpreting it. So this is what is called as judicial activism. Okay. Judicial activism as such is not wrong. Judiciary, by using its trained minds, by using the minds of the judges, they are coming up with newer and newer interpretations of the law which makes the parliament respond. Until then, parliamentarians are not able to understand this. Parliamentarians are just laymen, they are normal human beings, so they do not actually understand that life means all these. They thought life means someone just staying alive is life. But they were not able to understand the impact. They were not able to understand the necessity of having a educated life, having a independent life, having a sexual harassment free life. They do not know the importance. But the judiciary will throw light. It will point out, see, these are all areas which are necessary for this present day society. Please take care of that. Create laws. Okay. So now tell me, judicial activism, is it bad? Yes, Shivapriya, your interpretation is correct. Yes. Judicial activism as such is not bad. Judicial activism is always good. You need to have a very wide, very active, proactive judiciary, which interprets laws as per the changing needs of the society. Okay. So it is, as I told you, if the judiciary confines its activities to this, until the point the judiciary says having a clean environment is a necessity. If judiciary stops itself there is no problem. But the minute it orders Delhi government, go and buy air purifiers, there's a huge air purifier which I had seen when I went on a tour to China. Last summer I went on tour to China, very beautiful city. There is a large air purifier which can purify the entire house, entire locality. The cost of each purifier is only 200 crores. So why don't you buy that air purifier and install it? Buy some 100 purifiers and keep it everywhere around Delhi so that the air will be good. Once it gives these kind of orders, no, that is where the problem starts. Because whose mandate is it to decide what is good and necessary for the people? Is it the mandate of the judges? The mandate is that of the elected government. The elected government's work is to decide what is good and what is bad for the people. The elected government has decided now fighting COVID-19 is our priority. Air quality is next, second priority. Most important priority is fighting COVID-19. So the 2,000 crores has to be first spent on fighting for COVID-19, creating new hospitals, creating awareness campaigns. But judges are ordering, go and spend and buy air purifiers. And because of that, what is going to happen? The government is going to fail in its attempt to control COVID-19. And if it fails in its attempt to control COVID-19, what is going to happen? Next time when they go and face elections, people will not vote for the government. So that is how judicial adventurism. So when judiciary starts micromanaging the actions of the executive by giving its orders on what needs to be done, that is when judicial activism becomes judicial overreach, judicial adventurism. So judicial activism as such is not bad. When it goes beyond a certain limit, adventurism, that is bad for the country. Okay. So this is all about judicial review and judicial activism. Okay. So we'll move on to the next topic. The next topic is evolution of basic structure of the Constitution. Some examples of judicial overreach. I would say that Ayodhya verdict, no, where the judiciary said give them this much amount of land. What is the principle involved here in giving them 5 acres of land? Why 5? Why not 10 acres? Why not 2 acres? So judiciary dictating the minute aspects of governance. Okay, this should be left to the legislature and executive. Let them decide. There should be some scientific process thinking why extra land has to be given. Okay, so that would be a case of judicial overreach. And earlier there were examples when judiciary says Delhi government, municipal authority should catch all the monkeys roaming in Delhi and you should go and shift it to a forest area nearby. Okay, so that was all an orders which were given in the past by judiciary. So that can be considered as a case of judicial overreach. There are no clear-cut definitions of judicial overreach. it's case by case, context specific. Okay, what I can call as judicial overreach, you may not agree with me as a judicial overreach, but there's a broad consensus that if it interferes with the functioning of executive, if it places a burden on the executive unnecessarily, it can be called as a judicial overreach. So let's just discuss about how basic structure has actually evolved. Basic structure has evolved because of creative interpretation of the constitution by judiciary. It's an example of judicial activism, basic structure's evolution itself. So, so why did basic structure even evolve? Okay, so let's go back to history and let's try to find out why basic structure has had to evolve. First thing is, do you know what was the immediate need? Do you know what was the immediate need of the government after independence? As soon as the first governments were formed, okay, immediately after independence, do you know what was the most important task that the government was planning to take up? Yes, it is land reforms. 90% of Indian population in 1950, they were dependent on agriculture. 90% of the Indian population in 1950 were dependent on agriculture. And agriculture primarily depends on ownership of land, correct? But the problem with the Indian ownership of land in India was what do I mean by skewed ownership? What do you understand by skewed ownership? Communal riots, of course, yes. So that is a correct answer, basically, right? Dealing with the communal riots was necessity immediately after independence. The question should have been different. The question was, what was the objective after the governments were formed, after the first elections? Okay, I mean, or I will say, as soon as the constitution came into force, what was the immediate priority of the governments? Land reforms. So what do you understand by this word, skewed ownership of land? Small proportion owning large land resource. Yes, top 1% holding 99% of the land. Concentration of land in a few people's hands. Only the zamindars, the rich people, top 1%, they are having control over 99% of the cultivable land. Okay, of course, that was the biggest problem. So this was the reason why productivity is actually low, because the smaller farmers have no incentive to work hard, because there is no profit sharing. Whatever profit is there, only 1% will take, right? And moreover, it's not possible for that 1% to actually directly cultivate all the lands. They will have to lease it out to someone. That person will lease it out to someone. So subletting was a big problem. Okay, and what is the problem with subletting? And so subletting, leasing out the land, subletting, and tenancy. So what is the problem with tenancy? Do you understand? A tenant is someone who does not own the land. He is just occupying the land for some time and he can cultivate the land. That's called as tenancy. What is the problem with tenancy? Because our primary means of economic production is land in 1950. As I told you, 90% of the population were directly dependent on agriculture. So it's only if agriculture develops, the economic situation of this 90% will go up. So how would you develop agriculture? By solving the problems associated with agriculture. One of the problems associated with agriculture is tenancy. Why I say tenancy is a problem? Why do you think tenancy is a problem? For excessive rent. Yeah, of course, rent is so huge that the top level, you have a rich zamindar, then you have a petty zamindar, then you have large landowner, then you have the smallest farmers, right? He will pay, the small farmer, the tenant farmer, he has to cross these many intermediaries. These are all non-productive entities. They do not do any direct cultivation. He is the only productive force. They are just sitting in their homes and collecting the rent and doing nothing else. By the time he pays rent to each one of them in the chain, rent is 30%, 40% of the produce of that year. If whatever is cultivated, he has to spend 40% on these groups. He is the least profitable person in this entire chain, but he is the one who is spending the most amount of energy cultivating. So, of course, that is definitely one problem, but there is an even greater problem. Very correct. No innovation as they don't have ownership. If I am a sharecropper, if I am a tenant, okay, do you think I will cultivate and do you know how much money you can get if you cultivate teak wood? If your soil is conducive enough, if you cultivate teak in 1 acre of land, do you know how much money you can make after 20 years, 30 years? Any idea? If you have 1 acre of teak plantation, just from 1 acre, how much money can you make? A realistic amount. Just make a guess. 1 acre of tea plantation. If you sow teak plant after 20 years, after 30 years, how much money can you make? Just give me a number. No, just give a blind guess. Make a guess. Why is that? Okay. Very correct. Approximately 4 crores at present price. That's correct. That's correct. Correct. You are almost close. Current market rate of a teak wood is, if it is a 20-year teak, you can at least get 4 crore rupees in 1 acre. Okay. But 20 years is a long time. A tenant farmer, he grows teak. He cultivates teak wood. After 15 years, he is evicted from that land. The landowner over him, he says, enough of cultivation, you get out of my land, I am going to take over the cultivation myself. Okay. So his entire wait for 20 years is waste. He cannot claim anything. There is no legal protection for the tenants. And so no tenant farmer is actually incentivized. He will not make any investments on this land. If there is a ownership of that land, he will get loans. He will install drip irrigation mechanisms. He will bring in some scientific practices into that farming on that land. He will enrich the nutrition content of that land because he knows that he can cultivate for the next 10 years. He is ready to make investments. But if he has no security of that land, at any point of time he will be evicted. He will not do anything other than cultivating the same rice, wheat, rice. Throughout his life, he will only cultivate rice, nothing else. Okay. But his economic situation, his contribution to GDP can be improved only if you shift them to more cash-intensive crops, more cash crops and less of food crops, long-term crops rather than short-term crops. That's where the real benefits of agriculture can be tapped. But for that, he has to be assured of a security. How will you give him security without him being declared as a owner of that land? That is why you have to first come up with land reforms. And the most important component of land reforms is giving ownership. How can you give ownership of the land? Already land is scarce. All lands are in the hands of 1% of the rich zamindars. So you have to first take away their ownership of the land, and only then you can give them, you can redistribute the surplus land, correct? So that is why land reforms were the first initiatives that the government had taken as soon as the governments were formed in different state levels. Why? The central government cannot take any initiative on land because land is a state subject. Land is given in list 2 of the 7th schedule. 7th schedule talks about what matters falls under whose competence. So land as a subject matter falls under the competence of state governments. So only Tamil Nadu state legislature can pass laws regarding reforms of land inside Tamil Nadu, right? So various state governments, they all pass their own laws. Odisha Land Reforms, West Bengal Land Reforms Act, Tamil Nadu Land Reforms Act. It is for the purpose of granting ownership to small farmers, to sharecroppers, to tenants. They are also to be made as owners. But if you have to give them ownership, you have to take away the lands in the hands of large landowners, zamindars, and you have to give it in these people's hands. So when you have to take land from the hands of large zamindars, you are going to affect their fundamental rights, because at that point of time in 1950, there was a fundamental right of property. Okay, do you know what was the provision in the original constitution which actually talk about fundamental right of property? Any idea? That's very correct. Article 19. Article 19 had one A, B, C, D, E, F. I think F or G. Article 19G, I think, was the provision that dealt with fundamental right to property. Okay, so that fundamental right to property then became a legal right. Sorry, it became not a fundamental right. It became another provision of the Constitution at a later point of time. It was done in 44th Constitutional Amendment Act. Until then, there was a fundamental right to property as given under Article 19. Okay, so what does Article 13 say? Article 13 says any law that violates fundamental rights shall be declared as null and void. Okay, all these land reforms which were introduced for the purpose of redistribution of land now have the risk of being declared as null and void. Why? Because it is violating because it violates the fundamental right of property under Article 19. So that is why the land reform legislations are about to be invalidated by the Supreme Court, because they are violating fundamental rights. So now the state legislatures are helpless. So now they approach the central government. So the center states all have almost the same party, Congress party. So center government decides, okay, why don't we amend this provision, this chapter of fundamental rights? Why don't we amend fundamental rights slightly? That is why the very first constitutional amendment that was brought in was with respect to land reforms, was to protect the land reform laws that were passed by various state legislatures. The first Constitutional Amendment Act, it introduced provisions 31A, 31B. Two new provisions to the fundamental rights chapter was added by the first Constitutional Amendment Act. What were these provisions? 31A. If a law is for the purpose of land reforms, okay, if a law is enacted for the purpose of land reforms, cannot be questioned in any court of law that it violates fundamental rights. So they are creating an exception, some exceptions for certain laws, that even if it violates fundamental rights, it cannot be questioned in a court of law. Okay, Parliament is coming up with this provision called as 31A and 31B. 31A provides for land reform laws to be exempted. 31B is a list. It's a list called as 9th schedule. Whatever laws Parliament declares as a part of the 9th schedule of the Constitution. Okay, so Tamil Nadu Reforms Act, point number 1, 9th schedule. 2, West Bengal Land Reforms Act. So all the laws that are declared by the Parliament to be a part of 9th schedule will be immune from judicial review. It cannot be questioned in a court of law. Basically, it is the first Constitutional Amendment Act has only introduced these provisions. So now what happens? Now states are free. They just go about enacting their land reforms. They start giving effect to land reforms. Tahsildars go about taking away the excess land of rich people. They start redistributing it to poor people. Now the rich zamindars, large landowners, whoever have lost their lands, they are all very angry. Now they go to the court. They go to the court and file a case. Okay, so challenging the validity of first Constitutional Amendment Act, because it is only because this exception has been provided. It's because of the safety of this exception. Now these land reform acts are being executed. Okay, so now people who have lost their lands are angry. They go to the court. They file a petition challenging the validity of this first Constitutional Amendment Act. So from there starts the dispute. Okay, so the first point is a case called as Shankari Prasad's case. Shankari Prasad versus Union of India. Right? Article 31 is right to property. No. Article 31 was never related to property. Why would 31 be related to property? 31A, B, C, they are exceptions. They are not regarding property. Or am I wrong? Why is there a eerie silence in the group? Okay, what does the Constitution say? Whenever in doubt, let's have a look at the Constitution. I don't think Constitution had anything about property. Yeah, yeah, yeah. So this is not even there as of now. It's not there. It has been repealed by Constitution 44th Amendment Act. Of course, okay. Article 31 is about acquisition of property. It is not about right to property. It is about whenever a property is acquired, how much of compensation has to be made. That was what was given under Article 31. It is Article 19 which had the provision on right to property. Earlier it was mentioned that no one shall be deprived of personal property, right? No, no, no. Without paying a fair compensation, a person's property cannot be acquired. That was what was given in Article 31 earlier. Now you will find that in 300A. Okay. So this is the beginning of the dispute. This is the environment in which the first case is filed. The first name of the first case is Shankari Prasad versus Union of India. Shankari Prasad Dio. He's this surname Dio. They are all erstwhile Maharajas. Okay, so naturally they have a lot of my MLA. When I was working as a sub-collector, my MLA of that constituency, his name was Kalikesh Singh Dio. Okay, so all that from the princely families. So he controls half of the land in that subdivision. So he's a princely MLA, that guy. So that it's from that same lineage. You have all these people, Shankari Prasad Dio. So it's this Dio group of rulers who are controlling this central part of India, your Chhattisgarh, Jharkhand, Madhya Pradesh, Odisha. All these areas, it was ruled by this Dio rulers. So one of their ancestors, Shankari Prasad Dio, who was a rich ruler from a princely state, he was about to lose his land because of these laws. So he goes to the court, files a case. The name of the case is Shankari Prasad Dio versus Union of India. The first case that questioned the validity of the first Constitutional Amendment Act. Okay. So what will be the outcome of the case? What are the other cases that went into the shaping of basic structure? All that we will discuss in the next class with better energy. I'm very tired today, so I'll stop here. Okay, because once I start it, I have to complete it because I cannot stop it midway. It's only when I complete it in one go you will get that sense of continuity. So I'll stop here and I'll continue it in the next class. All right. Thank you, and go and make some study on judicial activism and judicial review. Have a look at the kind of questions that are asked from these two topics. Okay. So find previous year question on these topics. Study in the internet about what can be the better answers for these topics. Make your answers. Then you will have better clarity on how to make use of the knowledge that you gained in the class. Okay. Thank you. We'll meet in the next class then.